Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. In the hierarchy of judges, district court judges in the federal system are almost at the bottom of the ladder. I guess magistrates are one rung below them, but they don't have a great deal of power. They have to apply precedent as it's laid down by their Circuit Court of Appeals. And of course, that Circuit Court of Appeals has to abide by the precedent established by the United States Supreme Court. But sometimes I think district courts and courts of appeal must just really hate what comes in front of them and what they have to do. The case that we have here today is a case where, quite frankly, it is everything that is wrong with the doctrine of official immunity. It obviously cries out for some kind of remedial action, either by Congress or by the courts. And I would prefer Congress do the actual amending of the statute to eliminate what has become, I think, a license to violate the rights of individuals with no penalty whatsoever. And I think you'll be shocked by the facts of this case, and even more shocked by the outcome. It's called Shanita Terrell versus Harris County, and it comes out of the Fifth United States Circuit Court of Appeals. And I think if you look at the opinion, you'll find that the Fifth Circuit is not proud of this opinion. How do I know that? Well, it's this little footnote down here. This opinion is not designated for publication. Well, gosh, why wouldn't you publish it? Let me show you. Appellant Shanita Terrell alleged that two Harris County Sheriff's Office deputies forced her into a patrol car. Later, she alleged that one of the deputies did something that he clearly shouldn't have done. The district court dismissed Terrell's claim against the deputy, who is not accused of doing something wrong, and we're going to affirm that dismissal. At this stage, the court has to accept the following allegations as true and construe them in the light most favorable to Terrell. On the evening of February 23rd, 2020, at a bar called The Address, she was visibly and audibly confused. There was something wrong with her. She was not in her usual state of mind. At some point, Terrell encountered two off-duty deputies, Michael Hines and Mark Cannon. Hines and Cannon worked side jobs at this bar, and they were in their uniforms. And in addition to being in uniform, the deputies drove their county-issued patrol cars to work at this particular establishment. The deputies ordered Terrell into Hines' patrol vehicle, telling her they were going to take her home. She initially protested, but ultimately got in because she believed if she didn't, she'd be under arrest. Terrell awoke the next morning at home and discovered that something might have happened. She went to the hospital. They got some evidence, and they matched it to one of the deputies, Hines. She suspects that someone slipped Earl Hypnol, which is also known as roofies, into her drink at the address, and roofies is known by predators to incapacitate their victims. And then, 18 months after the incident, Hines was charged in what amounted to that encounter against Terrell. So Terrell sued Cannon, Hines, Harris County Sheriff Ed Gonzalez, and Harris County under 42 U.S.C. Section 1983. Hines was served but never responded, likely because he was in jail, and Terrell later voluntarily dismissed her claims against him. I find it amazing that it took 18 months when they had the evidence the next day. Terrell alleged that Cannon violated her constitutional rights by forcing her into Hines' patrol vehicle, and she alleged that Gonzalez was liable because he was supervising him. The district court dismissed Terrell's second amended complaint with prejudice. This appeal follows. A person whose constitutional rights are violated by an officer acting under color of law may sue that officer for money damages, but qualified immunity shields federal and state officials from money damages unless a plaintiff pleads facts showing 1, that the official violated a constitutional right, and 2, that the right was clearly established at the time of the challenged conduct. The plaintiff has the burden to show that her claim is not barred by qualified immunity. We may affirm the district court on either qualified immunity prong. We start with Terrell's prong 2 argument that Cannon's actions were clearly established as unconstitutional. Now, knowing what happened, even though I've referred to it very obliquely here, you have to assume that that would be absolutely wrong and it would be constitutionally impermissible for a law enforcement officer to do that. To satisfy prong 2, Terrell must point to legal precedent that puts the wrongfulness of Cannon's actions beyond debate. I think the wrongfulness of his actions are really pretty much beyond debate. They say that she relied on a case called Gomez versus Gallman, a Fifth Circuit case from 2021, but Gomez was decided in November of 2021, so it could not have clearly established the unconstitutionality of the actions that she suffered in February of 2020. It was constitutionally permissible for someone to engage in that conduct before 2021. I mean, is that what they're really saying? Is he really saying, "Oh gosh, I would never have done that if I'd known that that was wrong"? That's just nonsense, because obviously he was charged with a crime for it. The idea that that's not unconstitutional to commit a crime against an individual, again, it shocks the conscience that that would be the case. Alternatively, Terrell argues that Cannon's actions were so obviously unlawful that no precedent is required. The Supreme Court has denied qualified immunity in cases involving obvious violations, albeit rarely. Terrell does not show that her allegations are within the scope of those cases. But what's missing here? What's missing here is a discussion of the facts of those cases in the context of this case. They simply say, because prong 2 is not met, Terrell's claim was correctly dismissed. As to supervisory liability, they say that supervisory liability, a plaintiff must allege that the failure to supervise or train amounted to deliberate indifference to the plaintiff's constitutional rights. Terrell alleged that Gonzalez was aware that Hines was arrested for a similar incident in 2018, and that Gonzalez does not investigate or discipline officers alleged to have committed crimes if they are no-billed by a grand jury. In essence, the grand jury does not decide to indict them. But just because the grand jury might not have decided to indict them, that doesn't mean that there's not some presumption that maybe you ought to look at that officer a little more carefully. They say that to show deliberate indifference, allegations must infer a pattern of similar violations, and she only had one. And they say a single incident can show deliberate indifference if their highly predictable consequence of failure to supervise would result in the specific injury suffered. To be highly predictable, a result must be so predictable the failure to supervise amounted to conscious disregard for the plaintiff's rights. Terrell doesn't show that her allegations against Gonzalez satisfy that test. Well, I can sort of agree with the supervisory claim here, because as a supervisor, you can't be every place at once. But as to the officer that was part of getting her into that patrol car, if he knew what Hines had planned for her, I can't see ever not permitting that case to go forward. In essence, this is another case where police officers are given way too much benefit of the doubt. And that's especially true here, where essentially the officer has been charged with a crime as a result of it. This is one of those things that if you write to your legislators, if you write to your congresspeople, write to them and tell them you believe that this qualified immunity needs to be legislatively revoked, and it needs to be replaced with some kind of presumptive immunity that is rebuttable with a showing of the wrongfulness of the conduct. Because the idea that this would be excusable because this specific thing, even though it's clearly a violation of human rights, was not involved in case law prior to 2021, I just think that makes a mockery of our justice system. So that's my thoughts. If you have thoughts, I'd love to know what they are. Drop them in the comments down below. like, share, subscribe, all those things we always ask you to do. You know that. If you have any comments, you can email me at the address above. If you have the opportunity today, do something nice for someone. And then come on back, join me down here at the beach tomorrow. One little note. I will be celebrating my wife's birthday on Friday, and so there may not be content here on the channel on that day, just so you know. Thank you so much. Have a wonderful day, and catch me down here at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.